this, the court of the Texas Court of Appeals in 608 Southwest 3rd, 856, Reed v. State, has indicated that as a general rule, the instruction and the jury charged with conform to the allegations in the indictment. The jury charge may not enlarge the offense alleged and authorize the jury to convict the defendant on the basis or theory permitted by the jury charge but not alleged in the indictment. The hypothetical correct jury charge for the case must be authorized by the indictment. Furthermore, the law as authorized by the indictment includes the statutory elements of the offense as modified by the charging instrument. So we're alleging here that although the statutory elements do include the disjunctive language, the fact that not only the fact that were elicited during the trial, but the lack of objection by the state, even though they did modify the indictment specifically, allowed us essentially to rely on that and instead of or. And that essentially, by allowing the statutory language as permitted, would in fact modify the charging instrument that we relied upon heavily during this trial. We would urge the court to permit us to keep the language specifically as it is in the indictment, which states physical force and violence. Thank you, Judge.
Thank you. State.
Your Honor, as the council's argument, the state would cite support from case CADA, CADA versus the state of Texas, 334 Southwest 3D 766 at page 770 to 771, where in the Texas Court of Criminal Appeals states that the indictment and jury charge must contain at least one item from each numbered element, but may contain more than one alternative element. It is well established that the state may plead in the conjunctive and charge in the disjunctive. The indictment does state the language physical force and violence. However, as the court is well aware, it is well established law that the state may indict in using the conjunctive language and in the jury charge in disjunctive, making the language in the jury charge by the use of physical force or violence proper.
All right, and defense, since you have the objection on that point, I'll allow you final argument.
Yes, Your Honor, and I think it's critical in what the state prosecutor indicated, state counsel, that they certainly are, they may plead it and they may use this disjunctive language. It's permissible, except for that we relied on it. They had opportunity to change it. They did change a portion of it. And we elicited testimony and facts based specifically on this indictment, whether there was physical force and violence or evidence thereof, by at least two different witnesses. And that then becomes a factual issue that the court, I believe, must consider. And although they may do something, it's a case by case basis of what happened, what are the facts that permit you to do it or not do it. I would say, argue to the court, you may also not do it. You may say, you know what, I'm going to follow the language just the way it is. It certainly wouldn't be reversible error, but I would ask the court to, although to take into consideration that they had plenty of opportunity to clarify this issue to the court based on our examination of the witnesses. And they could have said, well, Judge, or they could have even asked the question, could it be and or. And I don't believe that was ever done. I never heard anything like that. So I think the only evidence we have is relate back to the indictment language, which is and we would ask the court to include the language by physical force and violence.
All right. The court is aware of all of the case law. The court has heard the arguments in the defense's objection will be overruled. Is there anything else with regards to charge from either side?
Well, Your Honor, there is a page that discusses the defense of intoxication. Defense counsel had actually pointed it out to me, and I don't believe it.
All right, that should not be in the charge. Oh, does anyone have a stapler remover? All right, thank you.
I believe it is the fifth physical case.
Any objection to removing that? The court will note that the court has not received any allegations of intoxication.
No objection to that removal.
All right, other than that, is there any other objections to the charge of the court? State,
No, Your Honor.
defense?
No, they're just a brief housekeeping.
Yes.
How are we going to, am I gonna have a copy of the indictment as it's going to be presented?
Would you wish to have a copy of the
Just so I
document?
can read from it.
Yes. And I will give you a copy that's in the court's file, if you'll just make sure it's returned to me because it's the
Is that what you
original.
wanted to make?
Sure.
Okay. Would you give me the moment, to make a copy?
Yes.
I don't want your response.
Yeah, maybe he can run and get another copy of the charge. I think we only have one.
Oh, you only have one copy?
Yeah, good.
I print off copies for Anthony.
Got one.
I can print another one off.
But let me put one. Should not print one. Thank you so much. Thank
Yeah, I want you to do it.
you. Judge, the one that, how we're changing it, the one that's gonna be altered, because we've removed and the mouth.
Yes,
So I
you'll have to print it and then just do the
Right,
white out
okay.
through it, yes. Diana? Oh, no problem. Thank you. And state with regards to your closing arguments, how would you like the time divided?
Your Honor, 10 minutes with Ruben for the introductory close, and then I'll take the remainder at 20 for rebuttal.
Okay. Okay, all right, thank you.
Divorce.
No, it's not amended, it's just, that's just. how we do it.
Are both parties ready to bring the jurors in?
Yes, and Judge, from my understanding on housekeeping, yeah, we're gonna come in here, we'll rest, and then I'm gonna ask for them to be removed.
Briefly, I'll just have them stand in the hallway briefly. Yes,
You ready?
yes, we're ready.
All right, for the jury.
And don't get too comfortable in your chairs just yet, okay? But have a seat. No. All right, everyone, please be seated. All right, defense, call your next witness.
Your Honor, at this time, defense will close.
Rest.
Rest.
State, do you close? All right, defense, do you close?
Judge, yes. But we would ask the court for one housekeeping.
All right, so ladies and gentlemen, just wait in the hallway for 2 minutes, and it's going to be exactly 2 minutes. That's why I told you not to sit down, right? My door longer to close every time. All right, please be seated. Defense, there's a matter you wanted just to take up before you closed.
We're gonna ask the court for a directed verdict. At this time, yeah. Gentlemen are having the court.
Yes,
Stay there and stay calm. It's long.
thank you, counsel. All right,
But
defense.
right now, the testimony, the evidence that's been presented, from both sides of the close, is insufficient to, for them to prove that that the defendant compelled the complainant to submit and participate by the use of physical force and violence. In fact, we've heard from 3 witnesses, including the alleged victim, that there was no physical force and that there was no violence. It's insufficient. There's no way that if they follow the law, that they will be able to fulfill the elements of the indictment. Of even coming close, even nothing's been presented regarding these elements. And we gave you case law, Judge. It's pretty clear that in this particular case, they found that there has to be something in the testimony, something in the evidence to show that this has occurred. That they're not the trier of fact. They are not the weigher of the weight given to the witness's testimony. It has to be done there has to be a scintilla of something presented that they can infer that this occurred, and it's been quite the opposite.
All right, state.
Your Honor, I disagree that there have not been. I also have case law. I disagree that there has not been a showing of physical force or violence. The defendant, well, according to the victim, the defendant guided her using his arm. He was the one who initiated any physical contact. He guided her with his arm to the back room. He was the one who lifted up her shirt, placed his mouth on her. He was the one who took off her pants. He was the one who inserted his penis into her vagina. The law does not define what extent of force is required, only that force is required. I do have with case law. Southwest 3rd 411. It's from the Court of Appeals here in San Antonio. And in that case, they held that the facts in each individual case determine whether force was used. And the facts in this case show that she was a new employee. She was unfamiliar with the restaurant. She was unfamiliar with the defendant. He was in a position of power over her. He was years her senior, and he was the one who was using that control and that power to physically guide her and advance with his use of force the contact between their sexual organs.
Judge, if I may,
Yes.
what you just described goes towards coercion, not force or physical violence. She's confusing the two. Nowhere in the indictment does it say coercion. It merely says submit and participate by the use of physical force and violence. That case law that we submitted to you for your review, which is Valdez, the state of Texas, it gives an example of force. Forced him. They're using even the example of holding on to him, certainly not guiding someone. That is not an example of force. It's in the very last paragraph before the conclusion. That they actually give you a very low burden of an example of force, of which this case did not present in the case in chief. There's been no examples of any force. In fact, when I specifically spoke to Ms. Jennings, she said no physical force, no threat. She specifically said that. I even asked her if she pushed. No, there was no physical force being used. We elicited that through several of the witnesses with the exact word force. Each of them said no force was recognized, including the alleged victim in this case. Again, the state is trying to make an argument for coercion. Coercion is not an element that has been listed in this indictment as a matter of means. It's not in there. Nowhere in there. Nowhere to be found.
Okay. All right. Defense's request for a directed verdict is denied. You can bring the jurors back in.
All rise for the jury.
All right, everyone, please be seated. Defense, do you close?
Yes, Your Honor.
All right, ladies and gentlemen of the jury, I'm going to read to you what's entitled Charge of the Court. You will be given a copy of this when you go back to the jury room, so you don't have to memorize it. Charge of the Court. Members of the jury. The defendant, Kadir Gunner, stands charged by indictment with the offense of sexual assault, alleged to have been committed on or about the 27th day of February 2018 in Bexar County, Texas. The defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of sexual assault if he intentionally or knowingly causes the sexual organ of another person without the person's consent to contact the sexual organ of another person, including the actor. 2, the sexual assault is without consent of the other person if the actor compels the other person to submit or participate by the use of physical force or violence. 3, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. 4. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 27th day of February 2018 in Bexar County, Texas, the defendant, Kadir Gunner, did intentionally or knowingly cause the sexual organ of Jayla Michelle Jennings to contact the sexual organ of Kadir Gunner, said act having been committed without the consent of Jayla Michelle Jennings, in that Kadir Gunner compelled Jayla Michelle Jennings to submit or participate by the use of physical force or violence, then you will find the defendant guilty of the offense of sexual assault as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date. The statutory limitation period for the offense of sexual assault is 10 years. Therefore, it is sufficient if the state proves that the offense of sexual assault alleged in this indictment was committed 10 years before August 29, 2018, which is the date the indictment was filed. You're instructed that under our law, no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have a reasonable doubt that evidence was obtained in violation of any provision of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America, in such event, the jury shall disregard any such evidence so obtained. You're instructed that a statement made by a defendant is to be wholly disregarded and not to be considered for any purpose whatsoever by the jury if the following 3 circumstances exist. 1, the statement is given as a result of custodial interrogation. 2, and prior to making such oral statement, the accused was not given the following warnings by the person to whom the statement is made. A, that he has the right to remain silent and not make any statement. B, that anything said by the defendant will be used against him at trial. C, that the statement will be used against him in court. D, that he has the right to terminate the questioning at any time during the interview or questioning. And E, that he is entitled to the services of an attorney, his own, or if he is unable to employ one, a court-appointed attorney, to advise him prior to and during any questioning or interrogation. 3, and the defendant did not knowingly, intelligently, and voluntarily waive such rights if they were given. A defendant does not knowingly, intelligently, and voluntarily waive such rights if the rights were given to the defendant in English, and at that time the defendant did not speak English sufficiently to understand the meaning of the words being spoken to him during the custodial interrogation. You're instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such statement for any purpose, nor any evidence obtained as a result thereof. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you're instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You're instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website to include, but not limited to Facebook, MySpace, LinkedIn, YouTube, Instagram, Google, or Twitter to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers or tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You're instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You're instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching a unanimous agreement, if that can be done without violence to individual judgment. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under an indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you ever retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. State and defense, are you ready to proceed with closing arguments?
Yes, Your Honor.
All right, state. You may have to.
Ladies and gentlemen, you've sat here for the last 3 days and heard testimony and evidence from witnesses by both the state and the defense. Now, before you go back to the jury room, as the judge has instructed you to deliberate over that evidence, I wanted to take a few minutes to go over with you the law that's applicable in this case. Now, with the jury deliberations, as the judge has said, you're going to select one juror to act as the foreman, and here, to aid all of you in deliberations. And they will be the ones that certify the unanimous verdict that you all come to an agreement on. You will have all the evidence that has been admitted, or all the evidence that has been admitted into evidence before you in order to come to your unanimous verdict. What we do want to stress to you is that any statements made by attorneys either for the state or for the defense that are not supported by testimony made by the witnesses on the stand is not evidence. You shouldn't consider any statements made by any of the attorneys that's not supported by anything that the witnesses have not testified. So you can take everything else back with you, deliberate over all the other evidence that we presented before you over the last 3 days, just not those statements made by myself, Ms. Mitchell, or the attorneys for the defense. Now to go over the specific laws over the law of sexual assault. Now, the indictment and the jury charge have told you that the state has indicted the defendant in that he committed the act of sexual assault on or about February 27th of 2018. And as you've heard in the jury charge, the state does not have to prove to you that it occurred on this exact date. All we have to allege is that it occurred on a date prior to August 29th of 2018, which was the date that this case was indicted. And in fact, it had all the state has to allege is that it occurred prior to that date, as the statute of limitations will not have run even until August 29th of 2028, because the law of sexual assault has a 10-year statute of limitations. So because it was indicted between February 27th, 2018 and August 29th of 2028, the state has proven this element of the offense, that it occurred on or about February 27th of 2018. Another element of the offense of sexual assault is without consent. And that is when the defendant compels the victim to submit or participate by using physical force or violence against her. And now a few days ago during jury selection, my partner, Ms. Mitchell, went over an example with you using this exact water bottle. Now, physical force, if I knock it over the table like this, that's physical force. I don't have to pick up this water bottle and slam it on the floor, splashing all of you, in order for that to constitute physical force. All that's required is some sort of physical touching to have the defendant submit or have the victim.
Objection to the statement of the law.
All right, ladies and gentlemen of the jury, the law is the law that's contained in the charge for you. Anything that is not in congruence with that is to be disregarded.
And all that's required is some type of physical force that has the victim submit to some kind of act. Again, I touched the water bottle and it fell over. You've heard allegations of the defendant guiding Ms. Jennings, the victim in this case, to the back room where he committed the sexual assault on her. He didn't push her, he didn't drag her, but he guided her with her arm. That's physical force. Again, the force is committed by the defendant, and under the laws of Texas, the degree of force required is, or the degree of force is not defined. So again, back to that example, doesn't have to be slamming, doesn't have to be dragging a person. All that's required is some kind of physical force. And further, there's no requirement that the victim resisted to that physical force. So you heard testimony from Jayla that she didn't do anything to fight back. That's not required. The victim in this case, Jayla, is not required to testify that she fought back against the defendant to prevent this act from happening. That's not an element of the law. The state does not have to prove that. Ms. Jennings does not have to testify to that. All that's required, again, is some kind of physical force by the defendant. Now, the elements that the state is required to prove is that in Bexar County, Texas, which has gone undisputed this entire case, the defendant, Kadir Gunner, on or about February 27th of 2018, which again, the state has already proved to you that this date has been proven, did intentionally or knowingly cause the sexual organ of Jayla Jennings to contact the sexual organ of the defendant, and Jayla did not consent, and that the defendant compelled Jayla to submit and participate by use of physical force or violence. I submit to you that the state has proven all of those elements beyond a reasonable doubt, which is the burden placed on the state in these cases. The first three elements have gone undisputed. You've heard testimony from multiple witnesses that the defendant intended to take her to that back storage room, pull down her pants, and sexually assault Jayla. During that sexual assault, he caused his sexual organ, his penis, to make contact with Jayla's vagina, her sexual organ. And you heard testimony that Jayla did not consent. She did not want this to happen. And the defendant compelled her through physical force by bringing her, guiding her with his arm from that table in the front of the restaurant to that back storage area of the restaurant. Jayla did not consent to walking over there. She was guided by physical force by the defendant to that back storage area. Because the state has proven all of these elements beyond a reasonable doubt, we ask that you find the defendant guilty. Now, again, you went over this with Ms. Mitchell, but just to bring it back up, the burden placed on the state beyond a reasonable doubt is not defined in the state of Texas. It's not required that we prove the defendant's guilt beyond all possible doubt. Just because something's possible doesn't mean it's reasonable. So when you go back into that jury room to deliberate, we ask that you use your reason and your common sense in deciding the guilt of the defendant. And just because you feel that there's an alternative theory, some alternative theory as to what happened, again, doesn't make that reasonable. It has to be reasonable given the evidence that the state has provided to you, the testimony and the evidence that the state has provided to you over the course of the last 3 days. So I wanted to bring up this example that you went over again. When we showed you this picture 3 days ago, you all said it was a gun, a puzzle of a gun, even though it's missing those puzzle pieces to complete that picture of a gun. Now, is it possible that those puzzle pieces are pictures of a little clown or something not like that? Sure, it's possible, but is it reasonable given what you see before you? So I'll submit to you, using all the evidence and the testimony that the state has provided to you, there's no other reasonable explanation of what happened to Ms. Jennings other than the defendant sexually assaulted Jayla on or about February 27th of 2018. And we ask that you return a verdict of guilty.
Defense.
Ladies and gentlemen, you have a tough job ahead of you. Cases don't come here that are cut and dry. That's why they're here in front of you. You have to hear the most difficult cases. This case is one of perception. And each one of you has a different perception of what you heard from that witness stand. And I'm going to go over that. I suspect there's many different perceptions of what the testimony revealed. The first and foremost is out of everyone here, I believe I was the only one involved with this case 5 years ago. There was a different judge, different prosecutors. I had the ability to interview witnesses, and I know you derived that from the some of the questions that were asked some of the witnesses about when I met them, when I first interviewed them. Approximately 5 years ago, 4.5 years ago. And I recognized at that time that certain things didn't add up. And that's why when we were talking in Verdire, I asked, there's certain cases of first impression, and then you have to double check people's paperwork. You have to double check to see if you can find an inconsistency with what they're saying. There were many, many inconsistencies throughout this. I'm going to go over them. I know you had to have caught all of them. The first is when Ms. Jennings got on the stand. Her statement was that she knew first he sent them home, then the employees, then that was their regular break. It came out. It also came out that they returned by the time she either came back out of the bathroom. I think she says the cook was there. So just look at that time frame. If their break was an hour to 2 hours, then something else was going on all this time. Her testimony was that the actual act did not last that long. That was her direct testimony. So if their break was an hour to 2 hours, what was occurring during that other time frame? These are the things you have to, we have to look at this with a jaundiced eye. We have to look at this very, very carefully because some things just don't add up. One is the timing of all of this. If in fact the people were allowed to go to break each and every day around the same time, which is when they did on this day, there was nothing suspicious about the timing of when they left. That happened every day. You've heard that through other witnesses, more than one. You heard it through the Abir, I can't pronounce his last name, the real estate agent that came to talk about the situation that he observed. You heard it through Jayla herself. You heard that was the normal progress of the daily schedule. Now, our position is that Kadir's not being charged with being a foolish man. He's not being charged with denying anything. He's being charged with sexual assault. There's certain elements, ugly elements that go along with that offense. One is that not only do you have to sexually assault somebody by penetrating them, physical organs, okay, but that you have to do so with physical force or threat. Now, I asked Jayla very clearly. I said, Ms. Jennings, did he force you back there? The answer was no. Did he threaten you? The answer was no. They were messing around during this time frame. And whether he should have known better, that's not against the law, because the answer is hell yeah, he should have known better. Does that make him guilty of sexual assault? What man is going to have sex or messing around with someone in their place of business and then invite him to a hotel room if he's perceiving that it wasn't consensual? It doesn't make sense. I'm going to assault you and invite you to a hotel room. That's from Ms. Jennings. That's what she told the first outcry witness, which was the manager of Burger King. And we got to hear from her. I tracked her down in Del Rio because I remember what she said 5 years ago. And what she said 5 years ago did not add up to a behavioral characteristic of somebody that had just been raped. We talked about that in jury selection. I said, is it possible that somebody would be laughing or giggling after an event like this? There was a reason I asked those questions in Verdire. Now, the scary part was I didn't know if I was going to be able to get her from Del Rio. She came up here because I told her how important her testimony was. That one little bit of evidence where she observed and recognized what was going on. Initially, Ms. Jennings came in upset, crying, she said. She placed her in the office. She gave her the instructions. This is an unbiased witness. This is not a statement. This is not a defense. In fact, both of us subpoenaed that it's a Carranza, Casares. That's how important her testimony was, that both of us subpoenaed her. She said that when she placed her in the room, first she was going to go to the bathroom. She instructed her, do not wash. That's a smart woman, do not wash. Second, she said she saw her on the phone calling her friend. And I asked her, well, which friend? She goes, I guess the one she works with. She had to instruct her to call her mom. And it's the one who called 911. At first, I have to say that I thought this was something of a regrettable moment, somebody regretting or feeling guilty of something that they allowed, somebody being interrupted by somebody else coming in and then feeling that they had to defend a decision that they made. And then what came to mind was this. The coworker, was it Roxy? Coworker. She took screenshots of the text that Jayla sent before she knew there was a sexual assault. That's what she testified to. She took screenshots to try to verify timing. This was going to come back to haunt them. Jennings, in the meanwhile, is in Burger King, talking to her on the phone, giggling. That time frame, those timestamps are minutes. You're going to look at the timestamps that they introduced of how quickly the police came and how quickly those texts were sent and how quickly the coworker had them already saved on the phone. During Verdire, the state got up and I thought this was strange. And I thought about it that night. Like, why would she say that? And during Verdire, she said, oh, this was during the time of the Me Too movement. Remember she said that during Verdire? Then I started thinking, two young girls, this huge movement of Me Too, and then these allegations come up. These allegations, not of just sexual contact, but of sexual contact against somebody's will. That's why we had this jury trial. We know that there was no physical force. No matter how bad they want to sell that to you, you all know there was no physical force exerted. You know that holding somebody on the back and guiding them somewhere which is what the testimony, but that's not physical force. I don't care how hard they want to make that fit. That's not going to fit. We already know there was no threat. The only thing I can think of why they're trying to get you to see things the state's way is coercion. And that's not part of the indictment. Coercion is not part of the indictment. So if you follow the court's law, not mine, if you follow the court's law, the indictment says that not only had he have to penetrate her sexually. I'll read this. Hereinafter referred to it as defendant.
Ladies and gentlemen of the jury, the charge is the law from the court. You may proceed.
Thank you. On or about the 27th day of February, 2018, Kadir Gunner, hereinafter referred to as defendant, did intentionally and knowingly cause the sexual organ of Jalia Michelle Jennings, hereinafter referred to as complainant, to contact the sexual organ of the defendant. Said act having been committed without the consent of the said complainant in that. So she can't just complain about it and say it's not consensual. In that, the defendant he compelled the complainant to submit and participate by the use of physical force and violence. So whatever your perception is, there was a reason I asked you to please hold back until everything was presented to you. I asked you that for a reason, because on first impression, what the hell would we be doing trying this case? Why? because it's this difficult. It's these details that you have to look at. You can't just come on board and go with the movement or go with the flow and think, oh, he had sex with her, therefore he's guilty. That's not what he's charged with. He's charged with using force, physical violence, and or threat in having sex. That didn't occur. The testimony from Jayla during that time frame, again, I need you to pay attention to that timing. She said it happened very quickly, and that she made it sound like there was, like, he kissed her, he lifted her shirt, and then he led her to the back. That's not what happened. We know that because the people were on break for so long, and when she came out of the restroom, she said the cook was there. Now, that brings me to another point. If there is a disagreement between any of you guys on what the testimony presented, the only way, I want you to listen to me very carefully, because this happens in every jury trial. The only way you're going to have the testimony read back to you is to say, we have a disagreement over this particular testimony, and we would like the transcript read back. If you ask it any other way, you will get nothing. It will say, please deliberate. And then you guys are going to go, okay, Zamora said that we can't ask for it. Now we have to ask for it specifically if there's a disagreement over the testimony. So remember, if you want testimony back, you have to ask for it in a particular way or you're not going to get it. I'll move forward. The other officer, well, I guess the first point of contact was that's listed in their reports as an outcry statement is ITSA. And I've already gone over her testimony. You hear from Ibram, who, and again, this is very important because it comes to timing. He comes to the place because he's on another errand. He's unexpected. And timing wise, the door is already unlocked. He walks in and they're both there, walking towards him. Now, that means that Jennings had already left the restroom. That means the cook was already there. That means time had already transpired. It's not, and it's in these details that you have to start questioning what you're hearing. You have to start questioning this. She also said that she did not sit down. She was worried about that they either were conspiring to do something, what have you. I don't know whether that's true or not. I'll move on past that. But if that was going through her mind, she denied sitting at the table. Now, in and of itself, how important is that? Well, it's very important in the detail. When you're looking at the details, when you're trying to make things make sense, it's very, very important, because what that means is it contradicts her testimony, her direct testimony of not staying. She sat down at that table. One of the gentlemen had tea. He doesn't remember if she brought it or if he got up and got it. That's important because it doesn't show that she's in this fear or rush to leave. Her report actually says, her statement, before she spoke to anybody. That Kadir went to the bathroom where she went to go put her clothes on. She was crying. He came to the door and asked, what's taking so long? I told him I was almost done and wiped my tears away.
Mr.
Yes, whatever.
Slow down.
Thank you. Sorry. The cook and another manager showed up and they were talking. They went outside, and that's when I grabbed my purse and sweater and ran out the back door. This is the same back door that opens from the inside. This is the same back door that is next to a room with no door on it. There is no door, it's open area. We know that's not true, even though she said it. We know that's not true. Whether we want to support her or not, we know that that part's inaccurate. And it's inaccurate because the witness showed up and said, we sat down and had tea. Ladies and gentlemen, nobody wants to sit here and say this person is inaccurate, this person is untruthful, or maybe she's forgetful, or I don't know what reason. Again, you all are going to have different perceptions of this. I'm just asking you to pay attention to what the facts show. You have to, as jurors, you're instructed that you cannot reach a decision based on sympathy or passion. You can't do it, or bias. It's a law that was given to you. You're going to take, you took the oath to follow it. This is not a, hey, I feel that this should happen. You know, I feel that that guy did, you know, he lied on the thing. Maybe he didn't understand the initial report, and that's even in the charge. And I'm going to let Mr. Cortez talk about that part. But ultimately, he's not charged with being stupid. Because as a businessman, this is stupid. This is so stupid. He's not charged with that. He's not being charged with denying, oh crap, I had sex, or maybe I didn't. Maybe that's the sharing. The state brought up that it's touch DNA. Well, does that mean that somebody could ejaculate in somebody's hands as they're rubbing and touching each other? They're the ones who brought that up. I didn't. They talked about touch DNA. I just started thinking, well, I don't know what's going through his mind. He's not charged with being stupid. He's not, and by the way, you know what? He's not charged with being older either. Many years ago, I married a woman that was in her early 20s. For somebody to say, Anthony's Murray, you're 25 years old, 22 years older than her. I'm a pervert now. I'm a weirdo because I'm an older man and I'm with a younger woman. She brought that up 2 or 3 times. That disgusts me, because what it says is we're okay to be biased and judge certain classes of people, but we can't do it to other people. We can just do it to the older people, the older men. We can do that to them. It's ridiculous. You have to catch yourself on these little nuances, because you can go back there and get excited about anything. You can get impassioned about many, many different things that may be wrong with this case. But those things is not what Kadir is charged with. Kadir is charged with raping a woman by the use of force or physical violence or threat. You never heard that from that witness stand. You never heard it. You're going to have to reread the indictment. The only thing I can think of that might be going through people's minds that even concerns me a little bit would be the word coercion, and that's not in the indictment. And coercion would mean that I'm coercing you. I am coercing you. That was never spoken. That was never testified to. Not only that, it's not the law. If you go back there and say, yeah, I think she was coerced, you still can't find her guilty. It's not in the indictment. She was coerced, not anywhere in here. Compel the complainant to submit and participate by the use of physical force and violence. That's the law you were given. That's not me giving it to you. That's not them giving it to you. That's the court. That's the law of the land. Ladies and gentlemen, I want to remind you, the reason you are here is because jurors have to hear the hard cases. If they weren't hard, if there wasn't something wrong with this, if there wasn't something wrong with this, we wouldn't be here. 80%, 90% probably the cases get worked out. The jurors have to hear the hard ones. We're asking you to set aside your emotions. We're asking you to set aside past experiences that might impassion you to view someone in a certain way. We're asking you to do that, and everything, if you stop and think about it for a moment, a judge many years ago told me that the whole courtroom was designed around you, because we have to ask you to step out of your normal day selves and to rise to a level to where you can judge the facts, no matter what those facts are. The way you are seated, you are elevated from everybody else. You're elevated. The design of the courtroom elevates you. Your oath elevates you, because you are no longer emotional people that can reach a decision based on emotion. You have to do it on what was presented from that witness stand. When you leave and when you enter, we all stand up. That is designed to honor what you are doing. We have to honor what we're asking you to do, because it's a difficult job. That's why we took so much time in Verdire to talk about the military service and then the service as a civilian. We know we're asking you hard job. But more importantly, we're not just asking you, took an oath to do it. Live up to your oath. You took an oath to not come to a conclusion based on bias, sympathy, or emotion, based on the evidence that was presented there. And you also, to make it here, gave an oath that if Kadir did not take the stand, and he didn't decide, we decided. We decided, myself and Mr. Cortez decided, he approved, we decided that the state hadn't proved their case. And so why would we subject him to get up there and take those shots? Why would we? And the English is so, I want to use the word pathetic, whether he has a basic understanding or not, we would have punished each and every one of you throughout the whole testimony. You cannot hold that against him that he did not take the stand. You swore to it. If any of you mention it, when you go back there, the other ones, the other jurors, the other 11, 12 jurors are charged with telling that individual juror, you cannot discuss that. Not only can we not think about it or consider it, this says you cannot discuss it. If one person brings it up, it is the duty of the others to remind them of what the law they are being charged with. Now, you're going to go back there, you're going to pick a jury foreman. That jury foreman is going to have the same equal vote as the rest of you. I encourage you to talk about the facts, to discuss them, and remember that if there is a discrepancy on how each or one or two of you perceive something or how you remember hearing it, you specifically have to ask. We have a discrepancy over this portion of the testimony, and we would like it written back to us and read back to us. If not, excuse me, you will get the note that says you've been charged with your duty. Please continue to deliberate. It's going to get quite frustrating. Don't rush through this, please. Take time to understand the law. Take time to understand what you're charged with. Understand Kadir hasn't gotten any, I guess, relief for 5 years. This is not just him, oh, I've waited 5 years. You're labeled. As soon as this charge, you're labeled. It doesn't matter. He's labeled after this. You heard that his mom said she got up there and protested. What do you think his name is in the community? Do you think it's Superior? No, that building closed.
Object to improper argument.
Sustained.
Ladies and gentlemen, I also want to remind you of certain facts. The DNA on certain things came back. There was 3 DNA samples recovered from Miss Jennings. One was unidentifiable. I didn't ask her mom any questions purposely because a mom's love is undivided, undying, supported. There was no purpose for me to ask her anything, not at all. And it didn't mean there was nothing. It would have been an emotional response that in my years, I should have expected it and would think is normal. And that's why I didn't ask her questions. She wasn't there. She has nothing to do with this case other than believe her daughter. Whether her daughter's being accurate or not, it's her job as her mom to believe her. We talked about the text messages that, again, when you go back there, you're going to be given them as exhibits. You need to look at the timestamps on those messages. It's going to indicate to you, and just look at it. Why was the immediate thing screenshot? There was an anticipation of what was coming before Ms. Jennings ever made the statement to the coworkers that she had been sexually assaulted. The timing is after it's occurred. The texts are sent to show that something is happening that's going to be produced later. Two young girls got together during the Me Too movement. Came up with an easy, stupid target. It does not change. Remember, any type of sexual contact, if it's, even if the juror members, and I'm sure there's some of you here that say, well, she came, she did all this. You talked about that in regard, about that once you started something, once you started that civil case and they didn't go forward with it, you don't get to stop. You just made a criminal accusation. You do not get to stop and say, I thought about it. Let me drop it. Oh, no, I'm inaccurate. Oh, no, I made the wrong statement. No, ma'am. It goes forward. Cases like this show up on the news 12 years later, 5 years later, 10 years later, when something else comes up and the jury has reached a decision. And you think whether you guys regret it or may regret it, you know, the scientist up here that was talking about all those odds, I finally figured out what Mr. Cortez kept asking about. Would you say that was beyond a reasonable doubt? Would you say that those things are, you know, so astronomical? You know, the excluded numbers that they were talking about. What he was talking about, that you have to be so sure, is that beyond a reasonable doubt. That's how sure you have to be. Those statistics that that scientist was giving you, when they talk about reasonable doubt, don't just say those words, reasonable doubt. You have to be pretty darn sure. They have to go beyond that. So you have to have reasonable doubt, and they have to go beyond that. That's why it's called beyond a reasonable doubt. They have failed. It doesn't matter how you initially view this case. It doesn't matter if you have sympathy. You have to understand that they have failed to meet their burden. This table doesn't mean that the state had ill intent. The state did their job as good as they could with the evidence that they had. They still fell short. They still fell short. You're going to go back there again, and then just stop and think even about the inside layout. This is a close-up photo that was introduced from the front door. They said they were sitting here. If somebody gets up to come lock the door and this individual wants to escape, there's plenty of room, there's plenty of time. The fact is they spent a lot of time in the restaurant because the workers came back from break. The fact is this door is a non-locking door and opens from the inside. It's not locked. The fact is that this is the storage room and there is no door or no way to restrain or force somebody back there. Those are the facts. That's why we had it introduced to help you look at these things. I'm going to sit down and I'm going to let Mr. Cortez talk to you a little bit more about the legal part of this. I hope I've covered the basic and gone over the basic testimony of the witnesses, and that no one, not even the police officers, not even the detective, said that there was any evidence of physical force. Ms. Jennings herself said there was no physical force. Her words, no physical force, not their words, not their, hey, this is not physical force. That's nothing. They're trying to minimize something here that is so huge. I want you to think in your own minds what you would use as that definition of physical force, because it's the same as law. Physical force is not guiding somebody. And again, the complainant herself said that there was no physical force. You have a difficult job in front of you, but it's not one where I don't think it's going to be clear after you discuss this amongst yourselves that you're not going to be able to come back if you follow the law with a guilty verdict. It's going to have to be, if you follow the law, and if you read that indictment, whether you like it or not, if you follow the law, you will have to return a verdict of not guilty. It's in the charging instrument itself. It's in the instruction. You know, I'm going to sit down again. But confusion sometimes is better than assuming something. And you're not supposed to be able to assume something in this court. This is supposed to be a court. This is the highest court with the highest I guess, ramifications. And so it's very, very important. If you're confused, that's a not guilty. If you're not sure, if you're certain that they had sex and he didn't threaten her or force her, that's a not guilty. If you think that she was coerced in some manner, even after reviewing the timestamps, that's still a not guilty. It's not in the indictment. It doesn't say coerce. It says physical force. They put it up there for you. Ladies and gentlemen, I take my hat off to you. You got a tough job in front of you. I know you're going to give it the time and attention it needs. I know you're going to follow the law. Not for me. You took an oath to follow the law. Mr. Cortez.
Yes.
I want to just remind you, you're here, protect the presumption of innocence against the prosecution. Just keep that in mind while you're here. I do want to use this example used by the state when they're telling you what physical force could be interpreted as. Like here. Is that physical force? Imagine if you did that with one of your children, touched them. Would that mean that you're guilty of using physical force against your child? Against a mate? If you're grabbing your child and grabbing him and leading him to wherever you're walking outside the backyard, you're guiding your child. Is that physical force? What if you put your hand on a teenager? Will you please get into your room? If that teenager calls the cops, physical force was just used on me. What kind of definition is that?
Argument, Your Honor.
All right, that'll be overruled. Ladies and gentlemen, the court has given you the law and the law is in the jury charge.
I do want to bring your attention again to the fact that Mr. Kadir did not testify. The presumption of innocence still remains 100% now. And you can rely on that and you cannot consider it for any reason. The other thing I want to discuss with you is on the charge, which would be page number. It looks like where it begins, you are instructed that under our law, no evidence obtained by an officer or other person in violation of any provision of the Constitution can be used essentially against that individual. And the person must knowingly, intelligently, and voluntarily waive his rights. If you do not believe that Mr. Kadir had that kind of understanding of the English language, you cannot consider any evidence obtained thereafter, including then would be the video. You heard the video. There's no way you can perceive that he clearly understood what was going on there. And if you don't believe that he clearly understood there, then the law requires you, compels you to disregard that video, and you cannot consider it for any reason. Now, this is important because juror number 1 over here can say, I don't think he understood that. I don't believe that he did. Juror number 6 can say, well, I think he did understand it. If juror number 1 said, I don't believe that he did, juror number 1 never has to agree with juror number 6. Never. If you don't believe he understood it, then you can't consider the video. If juror number 6 believed that he did, you can consider the video, but then you're going to have a problem here. And you're not required to agree. Understand that. Each one of you must make this determination whether he understood this, whether he understood he waived his rights. Each one of you, all of you. If 2 or 3 of you don't believe that, then you hold fast to that. And then you must disregard all that evidence thereafter. You have to. Now, what do we have here? I believe that we certainly have a far greater amount of evidence that this was consensual. They have the burden to show that it was forced use or violence. In fact, all the officers, the detective, the nurse, and the 2 detectives, they indicated clearly, including the Ms. Jennings said that no physical force was used against her and no violence was used against her. That's the Ms. Jennings herself saying that to you. The detectives corroborated her testimony and said, that's true, there is no evidence. They all said that no evidence of physical force, no evidence of violence. They all said that. Now, what evidence do we have that it was consensual?
I
The
would
evidence,
object to the mischaracterization of the
That objection will be overruled.
what evidence do we have that it was consensual? Well, she followed him to the back when she said, put his hand on the back. I don't know, but if he did that, that's more like guiding. She said guided. Did he guide her? She went back there without turning around or resisting or saying, no, I don't want to go back. What's going on? She entered the room voluntarily. And you know, she allowed for the blouse to be pulled up. I can guarantee you, if I reach over to Mr. Zamora and grab his shirt and try to take it off of, he's gonna just, what are you doing? I bet he would. If I did that to one of you and reached over and grabbed your shirt, pull it up, your first reaction is, wait, what are you doing? It's instinctive. You can't help yourself. She didn't do that. That's evidence that's consensual. When he pulled out her pants, imagine if somebody, your spouse or your friend or somebody, imagine one of your friends coming up to try to pull your pants down. What do? What's your instinct to stop that? You react to it. You react subconsciously, instinctively to these kinds of things. There's no evidence of that. She allowed that to happen. She allowed her blouse to be pulled up. She allowed her pants to be pulled down. She laid herself down. None of that was forced. None of it. That is evidence of consensual sex. It is. There's far more evidence of consensual sex than of physical force, that she was forced to do it. Much more evidence of consensual sex. If you look at it that way, it really is. Now, what else do we see? We don't see any evidence like the picture they showed of her in photograph. Her hair looked disheveled. She looks a little bit out of place. None of these individuals described her that way. In fact, when they came out from the back, the last witness, the Turkish gentleman indicated, she just looked nervous. And to me, I kept hearing the word nervous. And even the Burger King manager said she didn't look normal. Now, is that because maybe there was some kind of opportunity she automatically took advantage of? Did she see a man that didn't speak good English? He was the owner of a restaurant that, this might be something she could do. And it happened that fast. That seems more likely to me. It really does. Because you don't see any outcry. You don't see her coming out from the back from this one person she didn't know walked in. She didn't, when they were sitting by themselves, she didn't ask for help. She didn't say anything. She wasn't crying. She didn't look distressed. Distress is not nervous. Nervous would be if you're planning or plotting. That's nervous. That's the only evidence you heard. That's it. So I would tell you, please consider these facts when you go back there. Now, some of you, one juror may say, well, I do believe that she's non-consensual. But the other juror said, I think it's consensual. You're going to have a fatal conflict. You don't have to agree with each other. You don't. You don't. But if one of you does believe that it was non-consensual, again, Mr. Zamora has brought this issue up to you. Not only had to be non-consensual, how did this non-consensual act occur? If he got it,
object to misstatement of the law in public argument.
That'll be overruled.
if he guided her, what would you call that? Well, he got like you guide your own child, like you guide a boyfriend, like you guide a friend. Have you ever put your hand on somebody to guide them? Would you consider that physical force on someone? You can use your common sense. No, I guided them, but that's not physical force. And this indictment requires physical force. So even though I think that maybe she didn't consent because there was a miscommunication, the lack of consent didn't rise to the level where he did it by physical force and violence. So if one of you says, well, I don't think that she consented, then the next one must ask her then how, by what means did she not consent? With it, what compelled her then? Well, he put his hand on her back, but that at most is coercion. And if we find there's coercion, we must find not guilty. We have to. It's the law.
Argument.
Overruled.
It's the law, follow the law. There's nothing in here that says if it's non-consensual based on guiding, if it's non-consensual based on coercion, if it's non-consensual based on lying to her, hey, look, if you have sex with me, I'll give you $1 million. It's not non-consensual based on trickery. Look, if you have sex with me, I'll give you a pay raise. It's not non-consensual based on unequal status. Well, he's the boss, she's an employee. That's not enough. Even if you believe it's non-consensual based on any of those reasons, you still have to find not guilty. You must follow the law here. Please follow the law here. And all of you have the option, if you don't believe that the consent for the DNA, the waiver constitution was done knowingly with the mastery of the English language that was sufficient to do it voluntarily, then you have to disregard everything as part of that, and you cannot consider it. Even though another juror may think it was, that he did waive it. If one of you think that he didn't, you do not have to agree with each other at any point. You do not have to. And I think what we have here is mostly evidence that at most this was coercion. At most, it might have been an imbalance of power or position at most, but you do not have physical force. You do not have physical violence, and you must have that. You must have that. And the ones that think that it was not consensual, you're going to have to ignore the facts to show it was consensual. The voluntary, the lifting, the allowing of the lifting of the blouse, the allowing of the pulling your pants down. To go against your natural instinct to let someone do that and not hold up and not clinch, that's allowing someone to do something. You're allowing it. You're not resisting. That's consensual. But you do not have any of the elements required to find Mr. Goodyear guilty beyond reasonable doubt. And remember the level of certainty that's required here. And I put it to you, you should have the level of certainty that these scientists have. You should. You should be that certain like they have to be. Are you that certain about any of this, that this happened, occurred? What if it was one of you up here, one of your loved ones up here? Would it be sufficient? This kind of evidence? That you forced somebody? That you raped somebody? This is not enough. This could be any one of us. Don't let this happen to us. You protect our presumption of innocence. Thank you.
Right, State.
Hi, Mr. Honor.
Okay, can you? Is it set up? Yeah, you guys want. All right, ladies and gentlemen, you all heard the evidence. Heard the arguments. It's been a long week. We're almost there. And this is a difficult subject matter. It's difficult to hear. It's not something that in our everyday life that we think about. Unfortunately, Jayla Jennings still thinks about it. And when I'm thinking of this case, and I'm hearing these arguments about, oh, the age difference doesn't matter. This is what I keep thinking in my mind. Ultimately, this is a case about a man who knew he had control, intimidation, the upper hand over a young girl.
Judge, I'm gonna object to that. She's not a young girl. She's a young adult, possibly. She's not a young girl. She's a young adult, defined by the law as a young adult.
That will be overruled.
And used that intimidation that he knew he inherently had as the man who was hiring her, an older man, used that. And in conjunction with him physically using force, compelled her to engage, well, not to engage, to submit to his sexual actions against her. What was the evidence? We had testimony. We had Jayla, who came up here, honest, articulate, consistent, at times emotional. We had a mom, understandably emotional, honest, corroborated what Jayla told you. We had Karina, also emotional. She put her friend in this situation. She's seeing how this has impacted Jayla. 5 years later, she still cries over it. Again, she corroborated what Jayla told you. Timeline, everything. Miss Castros, she had her own interpretation of events, but above all, she called 911. And that audio from 5 years ago captured a small snapshot of the emotion that was going on at the moment. You heard from 3 officers, Detective Guzman, who was the initial handling detective, took the statement of the defendant, he submitted the same kits to the lab. Carvajal, who was just the responding officer, who on first appearance, you're kind of like, well, I don't know what he brought to the case. But then you actually think about what he told you, and you look at the timeline of what we know happened, and his testimony further corroborated what Jayla told you. That Kadir immediately started texting her, where are you? Where are you? Calling her. In the same time that she's not answering, he's looking nervous in his car, according to Carvajal, who had no idea what Jayla was saying. Detective Escarino came in and he just told you how he collected the evidence, which was also submitted to the lab. You know, there's dirty rags in the back room. He was the one that submitted, collected them. And the EMS worker, John De La Garza, also corroborated Jayla, her account, Karina's account. You had the same nurses, Casey Ward and Linda Whitty. And you had the analysts, Melissa Baldwin and Jamie Ponnicall. As far as the evidence you're going to get to take back with you, you have the text messages and the phone logs. They were the very first thing we admitted. And it's of those messages from Kadir to Jayla. Come, where are you? Come work tonight, please. Group, come now. She responds, where are you? So she can tell the cops where he is. Please come work. Missed call, missed call, missed call. You have various photos of the restaurants, the booth they were sitting at, a view into the back room, a view of the nasty floor, which is next to the 2 buckets that Jayla accounted had to be moved for him to find space to sexually assault her. You have the statement of the defendant. Speaks for itself, I think. If you listen to that statement, after Detective Guzman reads him all of his rights, he says, do you understand these rights? Defendant doesn't just say yes. He says, yes, I understand. From the EMS report, which right here. And it further corroborates the timeline, corroborates Jayla's emotional state, her pulse, as it is naturally going down once she has been further removed. It has her account that she says after, the exact same account she gave here 5 years later. The Snapchat messages that Jayla was sending to Karina contemporaneously at the same time. And we know they're at the same time because Karina is Snapchatting them. Obviously, her friend is in distress. And Karina knows Snapchat and she knows that they don't get saved. So she's being smart and she's saving them as they're coming. And we know it's as they're coming because the little emojis there showing that Jayla was actively on there as well. 301 corresponds to when he had just kissed her and she's freaking out. I don't know what to do. You're not working there anymore. He doesn't know I'm texting you. Just stay with me till my mom comes, because she was texting her mom too. And then it jumps to 3:13 p.m. So what could have happened between 3:01 and 3:13 p.m.? He sexually assaulted her. And that's when, once again, she can message her. And she says, hurry, he wants me to leave with him. You have the SANE report from Jayla's examination with Casey Ward. Now, it's exhibit 18. And among other things here, you can see the time, 5:24 p.m. So it's approximately 3 hours after the assault, 2 hours. And you see the allegations on here. You see that she's used the restroom already. You see that what she told Casey. You see that she had never had any sexual contact before.
Objection to the statement of the evidence.
That, ladies and gentlemen, the jury, you will remember the evidence as you've heard the evidence.
You can see the exhibit yourself. And as Casey stated, because as defense suggests there was no violence, meaning no injuries, no bruising. What happened with Jayla is consistent with the fact that there was no notable injury on her. We went over that a lot. You have the photos of Jayla the day of the assault. You have the photos of the defendant from the day of the assault. There she is, scared, about to have to strip down again. There's the defendant. Doesn't look very remorseful. You have the serology report. And when we look at these cases, we look for corroboration. In this case, we brought you a lot of corroboration. The timeline, we know that she applied on February 26th. We know that from Jayla, we know that from Karina, We know that from her mom. She was excited about it. According to her mom, she was cleaning the house. She was excited. She was going to be a waitress like her mom. We know from Karina that it was like mid-morning and it was Karina that drove her to work. We know that once they got to work, they stayed for a while. Both Jayla and Karina told you that Ollie and the busboy went on break first. And then when Karina stayed behind, it was the defendant who eventually told her to leave and take her 2-hour break, which Karina told you was unusual. We know the timeline thanks to the Snapchat messages of when he kissed her, followed by when he guided her with his arm to the back room. He pulled up her shirt. He pulled down her pants. He inserted himself into her. And Jayla, if you recall, said her arms were just by her side. And there was a lot from defense counsel saying, well, what, like a friend guides their friend on the back. He wasn't a friend. He was some strange man. She was in an unfamiliar building with a strange man by herself, and he's kissing her and guiding her with his hands. And the reason she didn't react, and yeah, it's a reflex when somebody touches you and you don't like it to go like that. But when you're terrified, you freeze. After the sexual assault, Jayla went to the restroom and cried. Defendant came outside the door, knocking on the door. What's going on? What's going on? Cleaned herself up. She told you she was worried about human trafficking. I think it was legitimate. Unfamiliar man does this to her. Another unfamiliar man comes in. She's terrified. You heard from Kadir's friend today. And we know they're friends because he goes to the restaurant so often that he pours himself his own drinks and he doesn't pay for them. That he came in and again corroborated what Jayla said, that they were speaking Turkish to each other in front of her. And what does he do? He sits down, and before Kadir has even sat down, he tells Jayla to sit down. Two strange men she doesn't know give her commands. She was scared. She was terrified. So she sat down. And what did she do? She looked nervous. She looked nervous. Not only nervous, but she was looking around like she wanted to go somewhere. That's what he said. She runs out the back door. We know from Miss Amara that the back door was, I believe she said, 6 car lengths or so away from the Burger King parking lot. So she runs out the back door when both men move to the front, which again is corroborated actually by Kadir's friend today. He said that she was there and then he went to take a call and he didn't know what happened. It's Amara who then sees Jayla come in crying hysterically, calls 911 at 3:12 p.m. You have the audio for that. You can hear her hysterically crying. And then that night, she's taken to the hospital and examined. Further corroboration of the actual sexual contact. We have the fact that her account on the stand, her account to the EMS worker, the account to Casey Ward, even though on the stand and back then is 5 years apart, is consistent. That's because she's telling the truth. We all know that when you tell the truth, it stays. Again, the Snapchat messages to Karina, the timeline, it matches. She tells Itamara, I've been raped. Also corroborating. She tells her mom that defendant took it, meaning her virginity. She essentially also told Casey Ward. We have the physical findings. Of course, by physical findings, I mean the DNA. We'll get to that in a second. We have the corroboration of her emotional state. You saw her and Karina on the stand. 5 years later, they still get emotional about it. You heard from Jayla's mom about the depression that Jayla had right after. She wanted to go and be comforted by her grandmother for 2 weeks. She couldn't work. She had to end up working with her mom one-on-one because she was too scared. You have the pulse rate in this EMS report. That's not something someone can fake. You have her hysterical crying. You have the fact that she's marked as tearful during the same exam. So the physical findings. Underwear that Jayla was wearing that day. Sperm matched to the defendant. Labial swabs of Jayla. Sperm and saliva matched to the defendant. Breast swabs of Jayla. Saliva matched to the defendant. Penile swabs of the defendant. Cellular material was detected, a match to Jayla. The underpants of the defendant. Cellular material, a match to Jayla. Other things to consider here. It was her first day of work. No one goes into a job, whether it's the Me Too movement they want to capitalize on or not. No one goes into a job saying, you know what, I'm going to have sex today. And I'm going to put on this big theatrical event and burden my life for at least we know the next 5 years while this case has been pending. For what? Attention? No. She had no idea that her very first sexual encounter was going to be the day of her first day at work. And I don't know if you caught the testimony from her mom. She had to stop working because she had another traumatic event. So this wasn't just anybody's first day of work. This was a huge moment for her. But no, she went in. It ended up being on a cold, hard floor in a strange building, dirty, nasty back room where there's rags with sperm on them. I wanted to remind you again of those Snapchat messages, 3:01 p.m. Just stay with me till my mom comes. So when Itza said that I had to tell her to call her mom, she had already been communicating with her mom. The fact that, and I brought this up already, Kadir's friend corroborates what Jayla said. Whether he realized it or not at the time, he was contributing to that intimidation that Jayla had. So of course she didn't run away until he was out of the picture as well. And again, to this idea that she's made this whole thing up, if she wants to, you know, for some reason ruin a man's life by having him arrested, why isn't she the one calling 911 and faking it's the 911 operator? She's not, because that didn't happen. She was terrified. She was in a panicked mode and she was trying to get out of there. And when Itzamara called 911, a wave of relief came over her. And just to remark that the English issue that came up, at no point in this trial did you see a Turkish interpreter here, because it's not needed, because he understands English. But then also, oh, now it's. Why would he deny it? Why would he deny it? Why would he act nervous? Why would he repeatedly call her that day? He knew he was caught. He knew he was toast. Jayla had nothing to gain from this. What it has bought her is from the age of 18 to 23, she has had to keep talking about this. She has had to have this lived over and over and over again. You know, in Bordara, we talked about, you know, why would someone make up a sexual assault allegation? Well, maybe they're angry with a family member. Maybe they want attention. Maybe they need money. All of these ideas came up. None of that applies to Jayla. Jayla was an 18-year-old girl. Her last job was at SeaWorld. She was trying to get out of her mother's house. He took away what should have been a very important moment of her life and turned it into the worst moment of her life. And she was brave enough to come here and talk to y'all about it. Please find this defendant guilty. We know they had sex. We know that Jayla did not want it. We know that he used that power, that manipulation to his advantage when he guided her back there, when he left her there, standing terrified, and stripped her clothes, ordered her to lay down, and took her virginity. We know beyond a reasonable doubt that he did this. So we ask that you find him guilty. Thank you.
All right, ladies and gentlemen of the jury, I'm going to have Ms. Renaud, if you'll remain behind. And you now have the court's permission to go back to the jury room. You'll choose the jury foreman, and then you may begin your deliberations. All right, everyone, please rise for the jurors.
Please or no? Yes, just give me 1 moment. All right, everyone else, please be seated.